of our weekly webinar. And tonight is a very pertinent topic, and something I think that's on the mind of a lot of people out there, a lot of our members and fellows, is to deal with the medical legal impact of COVID-19 in the delivery of surgical services. Tonight we're joined, as always, by our president, Professor O'Connell, but we also have Miss Margaret O'Donnell, who's an RCSI council member and a medical director at the Blackrock Clinic. And Margaret has a particular kind of area of expertise and experience and in the whole area of medical legal issues, and will give us a very interesting clinician perspective on that. And we have Dr. Rob Hendry, who's the medical director for the Medical Protection Society. And as always, the MPS are great friends of RCSI and great friends of many of us around the country involved in provision of services, and are been a massive support for years, professionally and in every way. So we're delighted to get Rob's perspective on this area. And then we have Miss Mary Hawk, who's a partner in Hayes Solicitors, to make sure we get the correct legal perspective on all these things. So it's going to be a good discussion, I think. As always, we ask you to send in your questions using the chat function or any comments that we can put to the panel at the end, and often that's the richest part of the webinar, is when we get into discussion on the various aspects. So we've seen a lot of changes with COVID-19 that are definitely going to change the medical legal landscape, from anything to do with patient consent, the communication of the changing risk that COVID is bringing to the delivery of services, to things like telemedicine and new practices and how does that fit. And I'm sure these will all be covered in the next couple of presentations that we will all see. So, as always, we ask the President to launch the session, give maybe a perspective of what's been going on and the topic we're going to discuss for the evening, and then introduce the speakers to take us through the session tonight. So, without any further delay, I'll hand over to our President. Ronan, over to you.
Thank you, Kieran. Good evening, everybody. And as Kieran has indicated, I think this is really a very topical issue. I certainly, on occasion, have had recourse to the MPS for advice, and Rob Hendry has been particularly supportive. And we're very grateful to you, Rob, for taking time to speak to our members and fellows. And I don't need to tell you that we in Ireland live and work in a very litigious environment, and many of us are concerned that the infrastructural and organizational deficits that we have identified time after time within the health service have now been exposed by the pressures of COVID, and that we are likely to face a very difficult period in the next coming months and year or two, with litigation arising out of delayed diagnosis or interval cancers and advanced cancers presenting when perhaps at the time there was missed opportunity to diagnose these earlier. Also very grateful to Mary Howe. Mary, I just saw you come online as we were starting out. Hayes Solicitors are known to all of us as being a major practice in Dublin, with a very large experience in litigation. I must say, any dealings I've had with Hayes have been of the highest professional standard, and we look forward to hearing from you, Mary, and your thoughts on, I think, the predicament we're going to find ourselves in. And to start off, my colleague, Margaret O'Donnell, who is known to many of you. She's a council member. She has a role as Director of Governance at the Blackrock Clinic, but has also had a strong interest in medical legal affairs and has been faculty on a number of symposia hosted by MPS. So, Margaret, I'll leave it to you to start the proceedings, and I look forward to a very interesting series of presentations and discussion.
Thank you, Ronan, and hello, everybody. I'm going to just get the slides up just a moment. I've been asked to give a surgeon's perspective, and despite the words medical legal in the title of this talk, I'm speaking as a doctor and as a plastic surgeon in clinical practice. I'm not a lawyer, I've no legal training. I do deliver workshops for medical protection, but as part of their educational faculty, not as part of their legal department. So just with a bit of background, I think we'll all in time have stories to tell our grandchildren about what we did during the pandemic. And I'll briefly describe mine. As Ronan said, I started initially with clinical governance role here in Blackrock, and subsequently over this time became a medical director. In mid-March, as we all know, because of fears that the health service would be overrun because of the COVID-related illness, the HSE made an arrangement with private hospitals in the state, and Blackrock was designated by the HSE as a, quote, non-COVID surgical hospital to decompress the public system and to deal with cardiac surgery and urgent cancer surgery. And I'll give you a few statistics. We received patients from 8 HSE hospitals, predominantly St. James's, but also Vincent's, Tala, Beaumont, Holles Street. We had 15 surgical specialties and subspecialties represented, really everything bar neurosurgery. So suddenly there were 30 new consultant surgeons, 11 consultant anaesthetists and their NCHDs, and we treated 1,052 major surgical cases during that 3-month period. And to give you an idea of the complexity, about 40% of the cases in the first 2 to 3 weeks were of the complexity that needed scheduled post-op intensive care post-op. So really within a very short few days, many new staff relocated from their public hospitals. They started working in an unfamiliar environment, undertaking highly complex surgery, interacting with existing staff who were previously unknown to them. And they were all working to new protocols in the midst of a pandemic. There was huge potential for conflict and for confusion. And so an enormous effort was made to communicate and to develop policies to allow for safe care. And it's really a credit to the visiting surgeons, the anaesthetists, the NCHDs, and the existing nursing and admin staff to have achieved this in a successful and a safe manner without any major incident. No patients developed COVID in the post-operative period, and there was no spike in mortality. With all of these variables, we've just been through on paper what should have been really a very high risk situation from a medical legal perspective. We've learned a lot, and some of it I hope will be useful to you. So how was this achieved? We developed a number of policies and processes. These were developed and circulated and revised as new information became available. These were based on national and international guidelines. And in the early days, really, while we were all struggling with the paucity of information, there were really a lot developed from first principles. It also depended on multidisciplinary involvement, which in turn was because of a good liaison and trust between the various clinicians and management. There were good communication channels between the different surgical teams and between management in the relevant hospitals. We had identifiable leads in each specialty and department, and regular clinical director meetings, both formally and informally. We developed one single pre-assessment pathway. The content of the pre-assessment changed, but the actual system remained solid throughout. So I think we can use some of these concepts to minimise risk to patients and to doctors as we move through these next few phases of COVID. When I've been speaking to surgeons, I think there are 3 real concerns. The first is a surgical patient contracting COVID-19. The second relates to the risk in delay of diagnosis. And the third risk to delay in treatment. The concern about a surgical patient contracting COVID stems from a number of, albeit small, studies internationally, which came out at the start of the pandemic, suggesting poor outcomes and increased mortality if a surgical patient concurrently develops COVID. And these have been discussed at some of the RCSI webinars. However, the risk of surgical patients contracting COVID now in Ireland, while not zero, is extremely low. This is partly because of low community levels, and also because of good pre-op assessment pathways. A single consistent policy in the hospital, not varying between teams or between disciplines, and organised through a single pre-assessment unit, I think is the key in our experience. And while the content of the assessment has changed, I do believe that the COVID questionnaire, if it's properly asked, is probably the single most important component. Swabs are taken as per HSE guidelines, and in our over 1,000 cases, no patient was admitted with COVID, even in the worst of the pandemic. Literally a handful of patients were deferred to have their surgery at a later, safer stage when their COVID status was clarified further. And in terms of the risk in delay of diagnosis and delay in treatment, it may well be that we will need to develop alternative pathways to help reduce these delays. We're not going to avoid delays, and this will be echoed worldwide. It isn't unique to Ireland. We may not be able to solve the delay, but we can certainly mitigate against them by having good communication and good record keeping. I don't think that doing your best in difficult circumstances will be sufficient defence, and it'll be interesting to hear the legal view on this. And I think we will have to look at good communication and good record keeping to help deal with this. And I'll expand a little bit on both of these. We can reduce the risk by improving communications, and that's communications between doctors and other staff, and between doctors and the patient. Last week, we heard from Professor McNamara talking about the possibility of transfer to different hospitals and units within a hospital group, but with the same surgical team, and that's an option. And then we will also potentially may have to deal with transfer to different surgical teams. That currently happens with emergency transfers, and it's also seen in some scheduled care, in some of the NTPF models, for example. And both of these realistically are going to become more common in the future. And both of these models need good planning. It's essential that good doctor-to-doctor communication happens in this situation. And unfortunately, historically, this hasn't always been the case when patient care is transferred. No one likes absolving care of what they see as their patients to somewhere else. And on the other side, receiving patients who've been seen elsewhere also can have its challenges. But really, if it results in timely care and good outcomes in which you can still play a role, it may well be in the best interests of the patient. And in keeping with the theme of this talk, it may reduce delays for the patient for both diagnosis and treatment, and ultimately reduce complaints and/or litigation. If patients are to be transferred, there are a lot of decisions to be made. Are you at the sending or the receiving hospital? Do staff follow the patient? Do you need to set up a non-cancer MDT to discuss case selection, what's appropriate, and to make agreed treatment plans? Can you ensure the patient will have appropriate investigations done and the results available, possibly including a COVID swab, so that there aren't any further inadvertent delays? In which hospital would the pre-op tests happen? And can the two hospitals together draw up a checklist and policies to ensure such smooth care? In other words, work out what's needed, then look around the corners and anticipate what could go wrong, and then how do you plug that hole? And these decisions all need surgical opinions and involvement. They can't safely be planned by clinicians, but they do need good management and involvement of our management colleagues. We really should be considering using the principles of lean management and other systems of achieving a safe and reliable practice, which the model ALIVE is one that's taught through medical protection, and using many of the courses and the processes being taught in RCSI and elsewhere. We also need to reduce risk by improving communication between doctors and other staff, particularly nursing and admin staff, and also where there are new systems and new pathways. We need to do this together. There will definitely be changes because of COVID. We know already that large numbers in waiting rooms will be a thing of the past. So what do we do instead? In our units, we're finding that careful scheduling has meant that high numbers of patients are still being seen and treated, particularly in minor surgery and in diagnostic areas. And it needs surgeons on these planning committees to establish what is a good and effective management of these clinics. Familiarity with these new systems takes a bit of time, as does staff gaining confidence, and particularly those who haven't been in their normal job maybe for the last 3 months or who've been given new tasks. And this is where good clinical leadership comes in. We've seen the nerves 2 or 3 months ago as new systems were introduced. We've seen the slow start and then the confidence grow. So actually we are now back at nearly 90% of the previous caseload in some areas. And as we see units opening in other hospitals, I think there's the same anxiety and apprehension that we saw here a few weeks ago when we were undertaking the new surgical practices. But undoubtedly activity will build again, and I think more quickly than might have been anticipated. I can see with good planning, really very quickly and safely, a probably new and better system can really develop. I think the biggest risk is between communication between the doctors and patients. Even prior to COVID, communication issues formed a large proportion of complaints and litigation. And our following speakers, I'm sure, will expand on this. And I think the COVID era really will be no different. Many studies show that the risk of a patient taking an action after an adverse event is influenced by the personal interaction between the doctor and the patient. The quality of this doctor-patient interaction is often more important than the actual outcome itself, or even the presence of negligence or error. One study found that 70% of the patients who commenced an action did so because of perceived poor communication that occurred before or after the adverse event. And we have this paradox that if a patient has had an error in their care or some significant issue, the treating doctor, quite rightly, will spend a lot of time with that patient, getting them through the problem. And interestingly, the potential for litigation from research is between 1% and 5% who've had a serious adverse outcome. However, a high proportion of cases that are litigated actually show no evidence of error. In some cases, 30%, 40%, 60% in one study. And there is this paradox, and it may be explained because if the doctor perceives no error has occurred, they are actually probably less time to spend with the patient explaining and treating the adverse outcome. And yet the patient's need for an explanation is the same. We maybe should consider the delay itself in this way. It may not be the delay that instigates the complaint, but it might be the manner in which the delay is addressed. Does the patient feel they were ignored or forgotten about? Or was there a sense that the doctor was actually trying to help to expedite the treatment? Was an alternative treatment selected, for example, radiation treatment instead of surgery, without explaining that the COVID restrictions played a significant part of the decision? It really will be really important to stay in communication with the patients, and particularly devising a system for rescheduling those whose care was cancelled. And it's worth considering giving the patient a copy of all the communications, for example, booking forms, GP letters, radiology requests, if that isn't already your practice. Consent, I think, goes without saying it's going to be an issue. Consent really is another form of communication, and the COVID restrictions will present challenges. There is a risk of becoming paternalistic and, inverted commas, deciding on a course of treatment for a patient without due discussion because of external pressures, because maybe a lack of space or because clinics are being done virtually and there are limited consultation opportunities. But this really falls foul of, this risks falling foul of what's known as the Montgomery ruling in the UK, which says that a patient should be told what they want to know, not what the doctor thinks they should be told. We have risks with virtual consultations, and there are definitely benefits. There are going to be a workaround some of the physical restrictions that we have with COVID, but care needs to be taken with consent in this situation, and about the accuracy of the diagnosis that can be achieved virtually. Maybe it is worth considering recording these consultations with a copy going to the patient. One UK study found that pre-COVID, 15% of face-to-face consultations were recorded surreptitiously by the patient. So it wouldn't really be surprising if that figure were higher for patients recording video consultations at home. It's just to keep in mind. Record keeping. I think record keeping is a bit like wearing a seatbelt and having an airbag in your car. You drive for years using them without needing them, and then maybe once in a lifetime it saves your life. Same with records. You write notes and no one else may ever read them, but maybe once or twice in a career it really will save you. You just don't know in advance which journey or which record is going to be the one. And really, I think it goes without saying that records should be complete, but in this case, not just what was done, but also the reason for the decision, particularly if you're going to have to justify a delay in treatment or a change in what might be the norm. And rather than just writing COVID in the corner, it might be also wise to keep copies of your own specialty-specific guidelines or any other guidelines, because they're constantly changing. And it may be hard to find a sequence of guidelines in a year or two's time when you have to justify or address a complaint, particularly if the guidelines have been overwritten or maybe taken down from the various websites that you've seen. For example, simple example, CT thorax was advocated by the joint colleges in the very early days for COVID pre-assessment, and that was very soon overturned. Or, for example, keep a date of the records that maybe your endoscopy room was only functioning for 50% of capacity because of COVID. So if there is a complaint later, the reason for the delay is more explicit. So obviously, guidelines can be used as a defence if needed, but some doctors do express a fear or even a distrust of guidelines or disagree with parts of them. And guidelines are guidelines, they're not obligatory, but it would be wise to discuss them with your patient and also record the reasons for not using guidelines if that's the route taken, and for maybe very valid reasons, but at least it shows that you're acknowledging their existence and making an active decision rather than just not being aware of their existence. And I think at the moment we do seriously have to consider that some of the international guidelines for case selection for surgery during COVID are being produced by countries where there's a significantly higher prevalence of COVID at the moment. So restricting patients here in Ireland may not be appropriate. It may be very appropriate to proceed with their care. So one needs to make the decisions based on the risk and the benefit, particularly if one is going to proceed despite tighter guidelines elsewhere. And finally, just a couple of thoughts about personal and professional responsibility. Again, studies show a high proportion of litigation is actually at the instigation of another health professional. This might be simple comments such as, oh, we wouldn't do it that way, this hospital. But avoid making adverse comments about the care given by others, particularly if there's delays or something different in the present climate. You probably don't know the whole story, and unless you do, you really can't make a valid comment. Another thing we'll have to consider is self-reported illness. Will we, as surgeons, self-report and self-declare a cough or a temperature even though we feel perfectly well? Will we do something we never do, which is call in sick? Will we cancel a clinic at short notice, or perhaps a list which has patients who've already been cancelled? We need to consider this change of culture, and it's something we will have to consider, and it may well need extra manpower to be able to deal with this. And can we constructively use our expertise to help open up the services? Will we join the committees which are planning the care? Will we participate in drawing up policies which we might have been tempted in the past to criticise? And there's really been excellent examples of good clinical leadership throughout the COVID practice here, including the public health leads and surgeons. So these last few comments really are just thoughts out loud, but things we need to consider, as some of these are personal decisions, but could be considered as risky professional behaviour and potentially lead to litigation or complaint. So really overall, it's a difficult time, and certainly there are fears that there might be an onslaught of complaints and or litigation. But the tried and tested principles of communication and record keeping, while they're important at the best of times, really, I think will be essential if there's going to be questions around our care of patients in the COVID era. And despite the threats, I think many clinicians are finding there are silver linings with COVID, and ultimately we would hope maybe it will bring a change for the better. Thank you.
Margaret, thank you very much. Very thoughtful, beautifully presented, and I think you've summarised all of the issues that are on our minds as surgeons at the minute. And so I'd like to invite Dr. Rob Henry to come and join us and give us a perspective from the MPS. Rob.
Thanks very much, and good evening, everyone. It's a real pleasure to be with you. For those of you who don't know me, I'm Rob Henry, Medical Director here at MPS, and I'm delighted to be able to say tonight I'm being joined by Mary Hoch, who, as we heard, is one of our senior solicitors at Hayes. She's head of the healthcare department there, and Mary and I do quite a lot of work together. So really just to move things forward, I have to say that was an excellent presentation by Margaret. Really, I think I would agree with absolutely everything she said. What I thought to do to move the discussions forward, thank you, was to look at some of the questions that members are asking us. And Mary and I'll do this sort of double-handed, if you like, and chat through some of this. We're very keen to encourage people here tonight to join in and ask their own questions, make their own comments as we go forward. So I can maybe just kick this off, because a lot of people are asking about, is there going to be a rise in the number of claims, complaints, and other problems as a result of the pandemic? What's that going to look like? Making predictions about anything is always dangerous, particularly if it's about the future. But I think it's very likely, looking back at our experience after similar periods of disruption, that we will see a rise in claims. We certainly saw that last time there was a recession following the global financial crisis in 2008. There was a rise in claims. Number of reasons for that. Clearly, there's not so much money to go around. People are looking to get money. Sadly, the plaintiff lawyers firms, this isn't a dig at the lawyers particularly, but if their businesses are suffering, they aren't making money from elsewhere, and we saw this a lot in 2008, they will turn to look at opportunities to make business, and they'll look around for people with deep pockets. And sadly, people will look at the medical profession. And as Margaret was saying, we know that less than 5% of people who actually have a good claim ever make one. So you don't need a large shift there before we see problems. So that, I think, is quite sad. And will we see the wearing off of the goodwill that accompanies the profession at the moment? Doctors being seen as heroes and so forth. But sadly, the public, I think, often, the people on a pedestal one day can sometimes be brought down to earth fairly shortly thereafter. So our belief and our planning is around the fact that sadly around the world, we may well see more claims in the wake of this pandemic. Which I suppose takes us on to the next question about risk areas. Now, Margaret identified a lot of those, and the President, I think, also mentioned some of them. And without going through huge details, because I think one of the things we'd like to get tonight is to think about what can you be doing to minimize these risks. But the risk areas undoubtedly, as the disruption to the normal ways of running practice and managing patients changes, whether it's consulting through telemedicine, whether it's changing the way patients are referred into yourselves for investigation and management of surgical problems. Where those changes have come into place, there is always going to be the potential for dispute. Margaret, I think, mentioned this issue of the interface between primary and secondary care. And certainly I've been seeing quite a lot in the trade press, particularly the GP press, about the issue of referrals being rejected or not being accepted. And I worry a bit about that. Just to take that further, I suppose and we know that the number of urgent referrals for suspected cancer have dropped for a number of reasons, including patients being less willing to come to healthcare facilities and so forth. But the ones I wonder about and worry most about, I suppose, aren't the ones where it's sort of barn door obvious that the patient has very suspicious symptoms, because I think they will be taken seriously and fast-tracked. I suppose it's the patients who have more vague symptoms, not immediately so worrying, but the type of ones who, if one does investigate with imaging and so forth, actually turn out to have an early malignancy or some other remediable condition. And the worry, I suppose, there is if for one reason or another the patient is lost to follow-up or falsely believes that they've been reassured by the fact that immediate investigations weren't started, that if they present some months later with a serious condition which would have been much more treatable or have had a much better prognosis earlier on, then it's likely that disputes there will arise and people will seek to apportion blame. So I think when we start to think about this area of dispute and of blame, how will they be sorted out? And that really brings us on to the next issue, and it's one where I'd really like to bring Mary in on from a legal perspective, but it's around the question of legal standard that doctors, surgeons will be measured against by the courts, by other tribunals, should someone claim that the standard of care was negligent. A lot of people have been asking us, does the standard change? To what extent are these unusual circumstances taken into account by the courts? And Mary, I don't know if you can join us at this stage, but I'd be really interested in your angle on that. There we go.
Mary, you need to unmute your microphone. Yeah.
Thanks. Sorry if
sorry
if that came as a surprise, Mary.
The very first hurdle. Sorry, I fell at the very first hurdle there. In short, the standard doesn't change. So the standard that medical practitioners are measured against in the medical legal sense in Ireland is against what's known as the Dunn principles. And that's whether you've been proven to be guilty of such failure as no other medical practitioner of equal specialist or general status and skill would be guilty of if acting with ordinary care. So that part hasn't changed. It's not going to change. I suppose the part of the burning question for a lot of people is to what extent will the, I suppose what we call the contemporaneous circumstances we have now be taken into consideration by the courts? I would say yes, they will be taken into consideration by the courts. They will have to be taken into consideration. But I think what's going to be really important is that with the benefit of hindsight, 2 years down the road, if a claim, and people have within 2 years, they can bring a claim, and sometimes a bit longer. But if a claim is brought and by the time it's being heard by the court, some of this is in the distant past, it is going to come back to what Margaret was describing there, and it's a great description, the seatbelt and the airbag of your good record keeping. And it is going to come down to the rationale underpinning the decisions made, and to what extent you have recorded and documented that. And that for us, in terms of defending any of you, is the most crucial thing. It's that it's documented, it's that there is something in the medical records, and it's not the simple COVID, it's got to have a bit more than that. So I think, as one of the speakers was saying, if you move away from guidelines for good reason, document it. I would say document, document, document. And I know everybody hates that. And I can't imagine how difficult it is when you're trying to don and doff PPE gear. And on top of that, then you've got to sit down and start making extra notes. But in terms of defending claims, that's going to make a very, very big difference. If we're able to set the scene for the court as to what the contemporaneous circumstances were, that is going to make the huge difference to whether a claim can be defended or not.
And I suppose, Mary, it's true to say that the standard the court would rely on still would be what an expert witness would say about the standard of care and whether it met the kind of reasonable doctor test.
Absolutely, Rob. And that, I know there's been a lot of controversy and I suppose a lot of media coverage in relation to some of the cases, and probably a little bit of confusion arising out of some of them as to what the standard is. But the standard has not changed. And the Supreme Court came out with a decision in a case called Morrissey. The High Court decision in that case, I think, did cause a lot of upset and a lot of concern amongst the medical profession, but it has been well and truly put to bed that the standard remains the same. And for us in defending any claim, it really depends on our being able to get an expert opinion from one of your peers to say that they would not have done anything differently, that the standard of care did not drop below an acceptable level.
And I just wondered, do you see that being an issue at the present time where different hospitals, it was interesting hearing Margaret talking about the arrangements they'd made at Black Rock, the protocols they've put in place. I mean, I just wonder whether there's a potential for tensions there, that if an expert is instructed from one hospital where they've done it one way, that there might be a different way of doing things in another centre.
I agree, Rob. I think there's potential there for an issue, but I suppose you will always have differences of clinical opinion, and it will be no different here in relation to how the various hospitals deal with COVID and deal with patients. In an ideal world, everybody would adopt the same gold standard approach. This is an emergency situation. Hospitals have taken different approaches. I think once we can provide the context within which those decisions were made and that pathway was followed, it should still be possible. It shouldn't mean that a case cannot be defended or a claim cannot be defended just because it was dealt with differently in one institution as against another.
Right. No, I mean, I think that's interesting. Again, I think we keep talking about this need for evidence, don't we? And being able to give our sort of logical account for the decisions that have been made. And people may want to ask us a little bit more about the standards, because I know that's been quite an issue for people. Really, just to move on to the next question that people have been asking, because there's been a bit again in both the trade and the lay press about protections. You know, to what extent, and again, it's about contextualization, because interestingly, in certain jurisdictions, like I know in New York, for example, they've actually introduced emergency legislation to give an immunity for doctors treating patients in the COVID crisis from claims for negligence, because I think there was a fear that doctors wouldn't be comfortable working there. Sadly, there's no such legal protection in Ireland, although I think it's true to say the Medical Council have said in rather broad terms that they will take into account the circumstances if there's complaints received about doctors. Don't know if you've anything to add to that, Mary.
They have, and the Medical Council, I think, have, I suppose, eased up in some sense in pursuing some of the complaints at the moment. But I suppose there isn't the blanket protection from claims that you're describing that they have in New York. And I think MPS have been lobbying to try to achieve that. But with our, I suppose, lack of government until recently, it's been difficult to see how that's going to come about, and I think I wouldn't rely on it happening, unfortunately.
No, and we've certainly lobbied a number of governments around the world in the same way, suggesting that would be a good thing, because yeah, I mean, there is this sense, I think particularly at the start of it, where there was a worry about the service being overwhelmed and people having to make really very difficult decisions and choices. Now, touch wood, in Ireland, that hasn't come about. You know, this idea that there wouldn't be enough ICU facilities, there wouldn't be enough ventilators and so forth. That hasn't happened, thankfully. But I think it is something we're going to be pursuing government with after this, because we need to learn from it and be clear on some of these issues should there be another pandemic in the future. And again, really just to pick up the last issue there, and I think it's quite an important one for people listening in tonight to think about, is there anything they can be doing to protect yourself from claims? Because sadly, if you're treating patients, there is always the potential for a complaint or a claim or whatever. And Margaret picked up a lot of stuff there. But I think we were talking earlier about this need for evidence to be able to explain why it was that things were done in the way they were, particularly if that was a deviation from normal practice. And I suppose that includes things like consent, and actually what do we mean by consent and getting a patient's consent in this circumstance? Again, we often are asked when we're doing telemedicine about should you be getting sort of consent, and I suspect a lot of surgeons now are consulting remotely in ways that they wouldn't be used to. And I think I saw it somewhere described as the profession going on a crash course to self-teach them ways of doing things. But I think certainly our advice to people in that circumstance, if you're managing patients in a different way, that you make fairly detailed records for that. Margaret picked up this issue of if you are giving patients advice, that it might be a good idea to put some of that in writing, to share a letter, which I suppose as lawyers, Mary, you do that every time you give one of your clients advice, but it's not been something that's been part of the medical way of doing things before.
Well, I suppose, Rob, the legal profession are probably hated by the medical profession for our obsession with writing everything down, and our emphasis on good record keeping. But when it comes to claims, I can't overemphasize the importance of good record keeping. And we have seen claims in the past, leave aside COVID, but we have seen claims in the past where it's very, very difficult to defend them because the records are so poor and there's so little contemporaneous evidence. And equally, we have successfully defended and won cases based on just good records that were a good, clear, contemporaneous note showing the rationale for a decision made, maybe an examination, the treatment provided, and it has been sufficient to, even in the face of a patient who has a completely diametrically opposed recollection, the contemporaneous note wins out. So although you will all hate me saying, write it down, I'm going to say, write it down, keep writing it down, write down as much as you can. And I think the suggestion that you would send some of the documents or letters out either to the patient's GP or to the patient, it's a really, really good contemporaneous note of what you're doing. But also from a communication point of view, it gives the patient more information. The patient can see that you are trying to look after them. And I do agree with the comments about how most and many of the people who come to bring legal proceedings do it because they have issues around communication, much less so than the actual care or treatment provided.
Yeah, it's interesting. I think Margaret also suggested this issue of recording consultations and so forth. And I was interested actually today, the Cumberledge report that came out in the UK about the use of surgical mesh and some other problems, which made pretty harrowing reading. But one of her Baroness Cumberledge's recommendations was that surgeons should consider recording the consent process and the discussion they have with patients. I think because there was quite a lot of dispute as to what had been said, what information had been shared. So maybe one of the silver linings of the new technologies is we might see more of that. The other thing I was keen to pick up on what Margaret was saying when she was talking about the new processes for managing patients in place, keeping copies of those, and also the version changes, because we've seen even over the last 3 months, the advice and the standard and what the protocols were are changing week by week. And should that be examined and sort of picked over in a court, setting 2 or 3 years later, it's really important that we would know the exact version that was in place at the time. And that can often be difficult to get your hands on, can't it? And I think you see that with the use of guidelines quite a bit.
We would encounter that quite a lot, Rob, where you go back to look for what was in place at a particular time. It particularly arises, I suppose, in the public hospitals, where they may simply not be able to tell us. And it does, in effect, tie one hand behind our backs when the criticism is that you didn't adhere to guidelines. So it is really important to keep track of the changes as they're happening. And that's no easy task.
Absolutely. So quite a lot to think about there. I'm conscious of time, and I just wonder if it would be a good time to hand back to the chair and see if there's any questions or comments delegates would have for us.
Rob and Mary, thanks very much. Very interesting. Very interesting conversation there and discussion on very important points. So we have one question. It kind of relates, I suppose, to that discussion we had on what happened in New York and indemnity and so on. So, a very good comment came in on the chat there about, the government stopped the screening programs, and we all know inevitably what that's going to mean. And, is there a, what's this, I guess we've probably covered it slightly, but we need to probably address, well, in the absence of a state indemnity for these matters, what is the best way that surgeons could help themselves in the event that the delays in diagnosis and so on should be? So maybe it's just to reiterate some of the good advice to date, but what would they look like?
Yeah, I mean, I think you're right, and it's interesting. The screening program's been stopped, both the national ones, but I suppose also the ones I worry about might be the patients you might be following up. I don't know, doing sort of regular colonoscopies, these other things. Maybe something the patients don't particularly enjoy, and this is good. This becomes an excuse for it not to happen. And then if something goes wrong, inevitably people will say, "I didn't understand what was happening. I didn't know what risks I was taking," and everybody starts pointing the finger. And I suppose that, just thinking of it in a practical sense, and again, I'd be interested in Mary's comments here, there will often be different versions of the truth as to what people think happened. And ultimately, and these are presumably the disputes that would often end up in court, is where different people will have a different account or a different understanding of what the narrative was, what the story was, and consequently where the blame lay. And I suppose that's where what we hunger for in all of these is having evidence that will support our members' version of events. And I think particularly at the present time, where there is so much disruption, it's all clear in our minds at the moment, but it's changing week by week. And in a year's time, it will be, it will not be clear. And whilst it's tedious and tiresome, actually, particularly if there's a patient you would have wished to have done something else with, but you can't, I think spelling it out in writing to the patient, writing perhaps to the hospital. I know there's been issues around private consultants not being able to follow up their private patients in the clinics in the usual way, depending on the contracts. I have to say, it's given me a lot of confusion as to know where some of the indemnity and so forth lay. But I think there is no doubt that having as clear an evidence trail as possible is useful. I don't know if Margaret or Mary want to add to that.
Yeah, Mary, before you come in, maybe Margaret, in your perspective, you heard there we have the challenge of the screening program stopped, so therefore there's possibly a delay in picking up things at an early stage. That leads on to maybe approaching a particular condition in a way that you made ideally, if we had more time, we'd have gone at it differently. And then the chance of some patients that were in the system falling between the cracks, as they say, and maybe kind of go back and re-examining those lists that of patients we had on ready to go, but then the list kind of fell away because of COVID, and now we have to kind of go and bring it back again. So from your perspective, how complicated is all that for you as a surgeon?
Well, I think everyone will find it's very complicated because you are going back even already, when we're talking about what looking back from next year, even just looking back from 3 months ago, when you look at lists that were planned or clinics that were planned, and by the time you go through them, try and contact patients aren't all, they're not as contactable in a bizarre way. We've had secretaries saying they've been trying to ring people, 10 or 20 times, and you would think people have nothing else to do but be beside their phone all day, and actually it's the reverse. A lot of people aren't easily contactable, or they've moved premises, or they've moved from rental accommodation. So actually even tracking the patients in this very short space of time, it has proven quite difficult for a lot of people. And I suppose keeping records that you did try to contact them X number of times, it's still all small chinks, but just important to keep track of all of that. But really going back through those lists and seeing, can you account for everybody, and will everybody get a new appointment, either with you or someone else? Maybe the thing is to be imaginative and really be thinking, is there another way of doing this? Is there someone else that could do it sooner or better or whatever?
Yeah. Roland, President, do you want to come in on that?
I think you might be muted, sir.
Yeah.
No, I'm muted.
Yeah.
I'm unmuted. Just something that Rob mentioned, and this is, for example, the patient who has had a colon resection and is due a follow-up colonoscopy in a year. And we know that's not going to happen because we simply just don't have the capacity now to do it. And there's a backlog. We've had 35,000 surgical procedures that haven't been performed in the last 4 months. How do we deal with this? Somebody is in the system and they're due something in August. Do we write to them and say, well, we're very sorry, but we just don't have the capacity to do this, and we'll get back to you when your name finally comes to the top of the list? But in the interim, is this the hospital? Is it the clinician? How do we deal with that?
What a nightmare! It's really difficult, isn't it? And I suppose there is a question of, why is there not capacity? Is that something we can offset to others? If there was a policy, is there does the hospital or whoever else is, I suppose, ultimately paying for this patient's care have an alternative way of absorbing that? And I know in some units they are, having to do extra working sessions, evenings, weekends to try to absorb some of this stuff. I suppose there is a question, and again, I'd be interested in the legal perspective on this, but I suppose if it's about a prioritization, what is the risk of delaying it versus the risk? So if you're doing, I suppose, an annual follow-up, what risk or what increased risk would there be by pushing that out to 18 months? I don't know, but presumably that's something that the patient would need to be informed about, because presumably, theoretically, they could seek that care elsewhere if they wanted to, if they knew what the risks they were running were.
Well, unfortunately, I mean, it's a capacity issue across the system. Unless it's purchased in the private sector, and then it's a resource issue. And we've been talking about this at length, doing Saturday lists, a 12, 14-hour working day. But that's not just resourcing the doctor, it's resourcing the whole team. It requires, and there's immense resource. And then there simply aren't the people out there to do it. I think about a CT scan. Unless you run CT scanners 24/7, we don't have the capacity to do the backlog, and you can't run them because there aren't the radiographers. I don't know how we break that vicious circle.
Sonia Gomer,
Mary, you wanted to come in there?
Sorry, just to say that from a legal perspective, I'm not sure the things I'm going to say are going to be terribly helpful. I think where there's a limited amount of resources available, you do have to prioritize them. But where you have a patient who potentially is at risk from these delays, I think you should be going to that patient and at least warning them that there are certain investigations they should have due to the resources. You're not able to provide it, and at least give them the option to go elsewhere. But that letter could then, I want to also warn, you could see that in the legal proceedings later on, that there's no easy answer to this one.
Yeah.
But this is of all of the things we've talked about, this is the most likely issue, I think, to come and bite us.
Yeah.
There's one other thing I wanted to raise, and this is the expert witness. And I'm sure our Mary and Rob, you are well familiar with the expert witness who comes into this country from another jurisdiction. I shan't mention where.
The bane of our lives.
Yeah, but who's not practicing in COVID, who's retired and really will come and give expert opinion about the care with no knowledge of the current difficulties. How will that be dealt with by the courts?
Ronan, that will be dealt with by cross-examination. I hope I got sound. That will be dealt with under cross-examination. We will annihilate anyone who comes in who hasn't been practicing in COVID and tries to tell the court how things should have been dealt with here. So I think that's where the good, strong defence comes in. And it's where certainly in conjunction with MPS, we are able to access really good experts, quite often Irish experts who are familiar with what is happening on the ground and are able to give that peer-to-peer support in an objective way in relation to the care that was given and the particular circumstances. But we're not going to be able to get rid of the experts that do jet in to give that type of evidence. We can just meet it in court.
Yeah, and I think, I mean, I absolutely, and I echo that. And it's the importance of getting people good, experienced jobbing surgeons who actually know what they're talking about in Ireland to be able to act as experts, because it's quite an onerous thing to take on. I know a lot of people shy away from it, but ultimately getting good expert witnesses make a heck of a difference. And as Mary says, to counter these, I know one English surgeon who was referred to as the seagull because he used to swoop in, do something unpleasant, and then fly off again. But they are a real nuisance. And I think all that we can do is counter it with strong experts, and of course strong lawyers, strong barristers, and some of the barristers that we would instruct would, I think, quite enjoy having a go at some of these people.
Yeah. Could I ask Margaret, because a very impressive amount of work that you guys in BlackRock stepped up to, and the way it seemed to work was very, very good. You emphasized good communication, that sort of thing. But was there any, if we're going to see a greater collaboration between the independent sector and the public sector, what type of actual more formal agreements need to be in place? And the role of the State Claims Agency, and I almost mentioned as well that we had hoped to get somebody speak from this clinical indemnity scheme tonight, but there was nobody available. But there is, in order for the public system to interact better with the independent sector and vice versa, what do you think we should have in place to manage that?
How long have you got? I think that's I don't know where you start with that. I mean, I take it very simply. A patient is a patient is a patient, and the people that came in, both surgeons, patients, everybody just got on with it, and there was no real concept of public and private. And actually, I think the sooner we break down that public and private and just get on with dealing with patients that's the only answer, I think. Sorry, short answer.
Rob or Mary, do you have any comments on that?
It almost picks up on Ronan's point about what we're going to do with these backlog of patients, particularly in the public sector where you're being forced to treat to a standard that you don't think is acceptable. And I think we somehow have to get this more politicized. I mean, the governments, and it's not just in Ireland, we see this all over the place, they are very keen to step away from these tough issues about funding of healthcare and so forth. They're delighted to let it rest with the profession. And we've had considerable concerns about this, certainly in the UK, but not quite on this point, but with this issue about allocation of resources, how would you make choices about who gets into ICU and so forth. We understand there was a government working party looking at guidelines, and they found it too hard. They stopped it. And they then came out in the department, and the NHS England said it's up to individual trusts to have their own policies. Well, that's hopeless, because, different trusts will come up with different policies. If things go wrong, if it's seen as being negligent or whatever, it all rests with the clinicians and with the management. And I think governments worldwide have really not stepped up in some of this stuff. And it's frankly outrageous that patients' lives and well-being would be put at risk because of inadequate funding, or if there are tough choices to be made for the politicians to face up to it, rather than shunting it onto individual clinicians and individual patients, which I don't think it's ethical.
Yeah,
sorry, that's a rather heavy answer to the question, but I think I think, as Ronan said earlier, it has really been stressing the healthcare systems, and it's really been showing up some of the weaknesses.
Yeah.
And it would be a shame if that wasn't used in some positive way.
I suppose the bit that everyone's concerned about is, and it's almost as usual, is that the institutions decide and the politicians, the departments decide certain models of care and care delivered, but it's the clinicians that are left carrying the can when something goes wrong, and then everyone heads for the hills. So that's always your challenge with this, and that so if we're going to have a model either where we're sending people, transferring them directly to a different care provider in an independent institution, what sort of is there need to be a contract there? There needs to be clear service level agreements, things like that. Do they add a layer of protection to the clinician, or actually do we just go back to basics and each clinician has got a responsible for the patient in front of them and deal with their own area? So do we need to think very differently about how we structure that sort of a model? Mary, what do you think?
That's probably me straying well outside my area to comment on it, but I suppose first and foremost, I would say you do have to look after your own patients. You do have a duty of care to your own patients, and you should never ignore that. I do think as well, though, there needs to be, I suppose, more publicity, more focus placed on it, and more lobbying to try and get the resources increased, to try to get the agreements in place. But none of it sounds to me like it's going to be easy. But I have the luxury of being able to sit on the fence and watch to see what happens. None of the rest of you do.
It's fair. Ronan, you want to come back in there?
Oh, I think you're still muted, Ronan.
It's most unlike me. Can I ask about recording conversations? Because anytime I ring an insurance company or a bank or even an airline, I'm told for quality and other purposes, they're recording my conversation. The only reason they're recording it is because in case I take a punt at them in some way. Should we be recording all of these consultations? And if so, what are the medical legal implications of having a telephone record?
Interesting. Does somebody want to take that one, Mary? Or, I mean, I've come back
Rob,
as well.
I should say MPS, I think, have an excellent podcast on this on their website, so I'll give it a plug for them. But I suppose you really need to be careful that you have patient consent. So all that insurance thing where they give all the chat at the start is part of trying to draw you in a consent sense. I suppose one fundamental difference that we would have seen historically is the doctor-patient relationship, and that relationship of trust and the fear that you could break down that relationship by somebody saying, I'm about to record our conversation. Things have moved on, I think, with so much telemedicine now. I think it's open to record, but you do need to have consent. And Rob might have some more comments on that.
Well, maybe Margaret has something to say.
Yeah, so it's just interesting. I mean, there's two sides to obviously getting consent. One school of thought that people are talking about reporting is whether it's been done as a fact by the doctor. but it's actually a very educational act, and it's a way of patients being able to recall or play back or play for their relatives, play with somebody who wasn't able to attend the consultation. And we do cover such an amount in a consultation that it's not unreasonable that patients do forget or can't remember part of what we call. So actually, I would see it as a sort of positive thing to be considering. And, you know, if you even take it as simple as a thing, whenever we get to go to a hotel again and somebody tells you to go down the corridor, turn left, take the lift and go up 3 flights, and you follow up and then you think, what did he say? You know, even the simplest of instructions, when you're not really concentrating, people don't recall. So I would think we should be looking at the recording concept as a positive thing and a pay.
Okay, looks like we have a bit of a broadband issue or something with Margaret there.
Yeah, but I would totally echo what Margaret was saying there. I think it will become more common practice, and I know some oncologists you speak to, they, you know, if they're breaking bad news, really by the time they use the word cancer or something like that, we know the patients zone out. And if they are talking about complex issues about treatment choices, being able to take it and share it with the family is good. At a much more mundane level, our experience, mainly with GP out of hours services and things which now record conversations, I would say 80 to 90% of the time, if there's a dispute about what was said, you know, the patient says, I told him clearly I had chest pain, and the doctor says, no, he didn't. I would say 80 to 90% of the time, the recording is helpful to the doctor. And I don't think it's because people lie, it's because they kind of can't remember what they said. And if something bad then goes, they say, I'm sure I mentioned it, or the family say, you must have told them that, didn't you? So actually, my experience is it's useful. And I suppose the only other thing to say is if you are making these recordings, that all the issues of data security, data protection, where you keep it and how it's stored and so forth. But I suspect over time it will become more and more normal.
Yeah. So guys, it's just coming up about 7:10 now, so it's probably time to wrap things up, as they say. Just to remind you, the college has put out guidelines on telemedicine and consultations like that, and many of the professional bodies have done so. And indeed, as Mary mentioned there, the MPS have an excellent podcast on that as well. So there's a lot of resources to help us how to deal with this new way of working, which I think are excellent, and they're all very much aligned, which is great. Just before I ask the President to come and wrap up with final thoughts, as we always do, just to remind everybody that next week we'll be having our last webinar for the summer. We're going to take a break in August, and that will focus on the impact of physician associates and looking at the kind of new structure of our workforce and how different disciplines are playing their part and have really come into the fore during COVID. I think it's highlighted that. So we'll have a very interesting discussion on that area next week. I myself will be on annual leave next week, so you won't be hosted by myself. We'll have a more than competent person to deal with that next week. So I'm going to hand over to the President now to wrap things up. Just to personally thank Mary, Rob and Margaret for their presentations tonight. Really excellent discussions. Thank you all for listening. Thanks to the backroom team for all of their work. And I wish everyone a very good summer. As we said, we'll take a break for that and we'll be back in September. So President, over to you to close out tonight. Thank you.
Well, thank you, Kieran. You haven't left me much to say. Again, thanks to Rob, Margaret and Mary. I thought the format was very interesting. A lot of discussion, and I think the important things have been raised. I'm going right out now to buy a dash cam and a body camera. So the next time I go and interact with the patient, I have all kinds of records. But I think that's where we're going, strangely. If it's the taxi drivers and the policemen and women are getting them, I suspect come 5 years from now, we'll all be recording all of these things, and it will not be who said what, it'll just be look at the evidence. Thank you all, and good night, and keep safe.
Thanks.
Good night, everyone.
Good night.
Thank you.